I was, given so much authorship on screen and off screen, and I feel so grateful for that because.
Can you do that
And
one
is
too?
there
Yeah,
any
just
chance
exclusive.
that we could
I'm
have a
exclusive.
sequence?
Colleen Hoover.
A
What?
chance that you can have a what?
A sequence, like it starts with this.
Oh.
I mean, if Colleen has her rights, I'll go anywhere. I'll follow this woman anywhere.
Y'all heard her.
Okay, I have.
Hi, besties. We have a lot to talk about. It is Wednesday, June 4th. There's been, again, a million filings in court related to Blake Lively, Justin Baldoni, and all of the people that we cover on this channel. And listen, before we talk about the stuff that's happening in court, I want to address something that's been going on behind the scenes. And apparently, there's been some divided PR that's going on right now. And I think I have a theory about what might be happening and why Blake Lively is unwilling to let go of this relationship that she has with Taylor Swift. So, if you are new or if you haven't been paying attention, we know, or we should know, that back in May, there was this allegation that was made that apparently Blake Lively, vis-a-vis her attorneys, had threatened to release text messages of Taylor Swift if she didn't put out a statement of support for her, allegedly, after she wasn't invited to the Super Bowl to sit in the box with Taylor and her friends to watch Taylor's boyfriend Travis play for the Kansas City Chiefs. And the conversations between Blake and Taylor had gotten so broken down that they were only communicating through their attorneys by February. And apparently Taylor's done. Okay. So I've talked to a couple people in the know about this, and as far as I've heard, it doesn't matter what People Magazine puts out or any of these other outlets that are friendly to Leslie Sloan and Vision PR. Leslie loves people, apparently, and they have been doing some articles on some of Leslie's clients, like Pete Davidson. And so Leslie and Blake are trying to, in my opinion, confuse the narrative publicly about this rift between Taylor and Blake. And I believe it's because if the narrative holds true, and if it is a fact that Taylor wants nothing to do with Blake, the fallout for Blake is worse than it would be in any other aspect of this case, because Taylor Swift's fans are notorious for kind of going after her perceived enemies or withdrawing their support for the people that have done Taylor wrong. And if it becomes a fact that Taylor and Blake are done, like a verified fact. Right now we just have sources that are speaking and saying that Taylor is done. Blake will be unable to change that narrative in any way. Okay. And then the Swifties will start attacking her. And then a lot of her fan base in the last 10 years has been built off of being Taylor's best friend. Because let's be honest, Blake alone and the movies she's been in the last 10 years don't warrant her having 40 some million followers on Instagram. So People Magazine wants to confuse us that, Taylor and Blake's relationship is on the mend, and they're taking space, but they're going to work things out. Okay. And you're not going to make me believe that this is true ever. And if anyone has good exclusives right now when it comes to Taylor and Blake, I would say Daily Mail seems to have some insiders with Taylor's crew, because apparently they're alleging that Blake has been effectively like stalking Taylor, sending her tons of text messages and emails and voice memos, and she's trying rather embarrassingly to win Taylor back or gaslight her. I guess no matter how you want to look at it. But a dramatic blow, according to them, says that even though Taylor has totally cut ties with her, Blake hasn't with Taylor. I mean, what? They're in a one-sided relationship? She's been reaching out to her with text, voicemails, and even emails, begging to mend what they once had. Blake isn't going to give up on trying to get her friendship with Taylor back on track. This is a woman that once said that she doesn't take no for an answer. Taylor hasn't responded to any of Blake's pleas. She's ignored all of her groveling excuses. And the messages explain that there must have been some misunderstanding on Taylor's part and that she would never do anything to harm 10 years of closeness and personal secrets. And she's been completely iced out of Taylor's circle, and nobody wants to talk to her. And according to the source, Swift has no plans to make amends. Taylor still means so much to Blake, but Taylor's totally done with her. And as of right now, no requests will mend their bond as far as she's concerned. There are some things that you go through with people and you realize they're not my people and you cut ties. And that's kind of the status of where she's at. And, I think if someone were going to threaten me and try to reveal my secrets, that would be a turning point for me, right? Like if someone's going to try to extort you. I mean, let's be real. That's pretty messed up if you're going to try to do that to someone who you claim is your best friend. So, Taylor and Blake, this narrative that you're seeing publicly, it is just a game of PR where Taylor's PR is trying to make it appear and be very clear that she is not friends with Blake. And Blake's PR is trying to confuse you guys that there's a possibility that they could be friends again and that it's all a mistake and that it is actually Justin that did this and it's not her. Again, scapegoating Justin. You know how if you watch Sister Wives, Christine Brown is like the scapegoat? Everyone was like, blame Christine, blame Christine, blame Christine. Justin has officially become Blake's scapegoat for everything. Blame Justin for everything. Everything. Justin is the fault of all things. And despite the glaring holes in her case and this massive cover up that she's doing with the media, the mainstream media continues to not believe that she's not a victim. A lot in the media are still supporting her victimness. If I've learned anything about Blake Lively in the last 5 months, which before then I knew next to nothing about her, it seems that her proximity to power and being surrounded by people with power is something that she desires and wants. And so the idea that someone very powerful and someone very famous and very beloved rejecting her would be something that she would want to conceal and hide from the media because obviously it would be a question mark on her credibility, a question mark on her likability, a question mark about the veracity of the claims that she's making against Justin. And Taylor has not spent time with Blake since last October. It doesn't really matter how many times Blake goes to the press and says that they're best friends, but it's not true. And if she truly is texting her and contacting her and not respecting her boundaries and not accepting the answer no, it shows a pathology of her that's truly unwell, unhinged, no boundaries. But what do I know? Other details that have come out in the last couple days is that Ryan Reynolds has a movie that's coming out. It's like an animation that was supposed to be released by Sony, and then it got punted to Warner Brothers, and it was supposed to come out in October. And now they've announced that the movie won't be released until May of 2026. And that's an interesting timeline because this case is supposed to go to trial in March. It's like they're waiting to have his release until after the trial is over. I don't know if Ryan's involvement in the film is what caused the delay. Movies get delayed for a lot of reasons, but delaying a movie for that amount of time, I mean, it does cost the studio money. They haven't given a reason for why the movie is getting punted 7 months, but it seems to coincide with the current trial issues and maybe the marketability of a film in theaters if people no longer like Ryan Reynolds. And Ryan hasn't appeared in a movie in theaters since last July when Deadpool and Wolverine premiered. So he's almost a year out from any major films being released connected to him. And if this doesn't get released until next May, it would be almost 2 years since the last time he appeared on film. Makes you wonder how profitable this man truly is. And to add insult to injury for Ryan Reynolds, to be clear here, Baldoni and Wayfair are now seeking sanctions from Ryan Reynolds because they are claiming that he brought forth the Rule 11 sanctions against Wayfair and, well, not against Wayfair, against Heath, Abel, and Nathan, and it ends with us LLC frivolously. And much like the same reasons why they were contesting Blake's sanction letter, they've basically argued the same case and said that Ryan disregarded the rules, he disregarded their warnings. They tried to explain what sanctions were for and what they weren't for, and he instead went for it anyway. And now, because it's been filed, they are asking the judge to deny it and then award them attorney's fees and sanctions because they want to deter Ryan and Blake from continuing to file needless motions against them that are frivolous and outside of the rules. We've already seen that the judge has been less than thrilled or even interested in doing anything related to sanctions. So ultimately, we'll have to see how they work, how they move on that. So Blake is stalking Taylor. Taylor is done with Blake. Ryan's movie is delayed. And now I have some even more bad news for Blake Lively. So a new amicus brief was filed by Child USA. And listen, I don't want to discourage and disgrace these nonprofits that are writing letters to the judge. I truly believe in the case of Child USA, they don't say anything about Blake. All they said was just don't dismiss it and claim this law is unconstitutional. They're only asking the judge to keep in mind the reasons why this was put into place, and that even if Baldoni's claims are brought in good faith, this law is still not unconstitutional. And they argued why the law is not unconstitutional. There is some fear by these leading nonprofits and lobbyists that this law is vulnerable to being overturned in court. And they're making a very big display at the federal district level, which I find odd because generally these briefs are filed at the appellate court and Supreme Court level. Because I did some research here. A federal district judge can decide whether or not a law applies or not to his case. So they can rule that this law for him is unconstitutional in this court. But that doesn't extend then to other courts. It would only be in this court in this district. So it would mean we don't apply the law of 47.1 in the state of New York in the Southern District. Okay. But if they were to then appeal it and it goes to the appellate court and the appellate court then were to overturn and say, and to agree and say, you're right, it doesn't apply to the New York court. And then they were to go all the way to the Supreme Court, which, by the way, the Supreme Court doesn't have to decide or take a case of any kind. If they were to go to the Supreme Court and the Supreme Court were to agree and overturn the law, that's when a law is deemed unconstitutional. So the federal district court level is not really the place where it's ultimately decided. It's the Supreme Court that overturns laws or affirms laws. That's part of the checks and balances in the United States. So I think there's a lot of really big nervousness. And part of it is because Justin Baldoni's argument in his motion to dismiss is that aspects of this law are unconstitutional. This was actually brought up on page 2 of his opposition to Blake's motion to dismiss. And their argument in that part of their motion to dismiss was that Lively is still not entitled to the award of fees, costs, trouble damages, and punitive damages that she seeks. The draconian one-sided sanctions that Lively demands under the Civil Code 47.1b are in a matter of first impression barred by the Norr-Pennington Doctrine, which precludes the imposition of liability for the exercise of rights protected by the Petition Clause of the First Amendment. And the First Amendment protects the right to petition the government for redress of grievances. In other words, the Constitution safeguards America's rights to ask the government to take action, such as bringing legal claims. The Norr-Pennington Doctrine bars courts from punishing litigants for bringing good faith claims, including through the imposition of harsh penalties like treble damages award Lively seeks here. Because they have brought good faith claims against Lively, that are neither objectively baseless nor subjectively brought for improper purposes, the First Amendment protects them from being punished for the act of seeking relief from the court. They're saying the motion must be denied or must be granted with leave to amend. In no event on this motion at any stage of the proceeding will the First Amendment permit the extreme and unconstitutional award of fees, costs, and trouble and punitive damages that Lively demands. Trouble damages in federal court are super rare. And so there's a lot of questions about whether or not they would be applied. And it's Wayfair that is being forced to fight this because it's being brought into this case, and Blake is misusing the law herself. And it feels like she's using it as a shield. And while I understand that some of these nonprofits have the best intentions at heart, aspects of their motion to dismiss don't outright say that the law itself is unconstitutional, just aspects of it. Because when they argued that the privilege doesn't apply, their argument to the judge was that it applies only to communications made without malice. Subsection C further provides that this section shall only apply to an individual that has or at any time had a reasonable basis to file a complaint of sexual assault or discrimination. Those requirements that the communications be made without malice and with a reasonable basis in fact are why Lively's arguments fall flat. As alleged in the FAC, she fabricated her allegations of sexual harassment either wholesale or by exaggerating benign and not harassing interactions in a concerted malicious effort to seize control of the film and later to restore her reputation after a well-publicized series of marketing missteps that sullied her reputation. So in their own motion to dismiss, they're saying under the law, this privilege only applies if it's without malice. And they're not disagreeing. They're just saying that Lively had malice when she made these claims. So some of these amicus curiae really don't take into account that Wayfair isn't arguing that it's unconstitutional, and they're actually saying the treble damages part of it and all of these penalties are unconstitutional, and because you're penalizing someone for bringing a lawsuit. And in order for them to show examples to the judge as to why they believe this was malicious, they gave examples of their allegations of her behavior, that she falsely claimed that there was no intimacy coordinator when Lively was aware that one was engaged 6 weeks before filming began. And although she refused to meet with her in pre-production, forcing Baldoni to personally relay the coordinator's suggestions about the mechanics of an intimate scene. Lively falsely claimed that certain of the Wayfair parties insisted on being around her when she was undressed or breastfeeding, when in fact, Lively openly breastfed on set and no one ever entered her guarded trailer without advance permission. The FAC includes a text message from Lively to Baldoni from after the event she later recast as sexual harassment, inviting him to her trailer while pumping breast milk. So if she was sexually harassed, why would she then invite him into her trailer for pumping her breast milk, is what they're saying. She falsely claimed that she was forced to be nearly naked during the filming of a birthing scene when in fact she was wearing black briefs, a hospital gown, and a pregnancy suit and only showed her legs. Lively falsely claimed that Wayfair hired a random friend of Baldoni's to play a gynecologist when he was a trained actor, blah, blah, blah. She falsely claimed that she was shown porn by Jamie Heath when it was actually a birth scene, which was being used for creative purposes to show her what their idea was for birth. She falsely claimed that he harassed her during the filming of a purportedly soundless slow dancing scene. She falsely claimed that Baldoni fat shamed her. And she falsely claimed that Baldoni admitted to committing sexual assault when in fact he had disclosed that he had been the victim of sexual assault. And I mean, some of these are evident in that Ryan has stated in his motion to dismiss that he believes that Baldoni is a sexual predator because of the false belief that something he said on a podcast discussing consent with a nonprofit for victims of domestic violence, that was an admission that he was a predator. What I've learned about Blake Ryan and Stephanie Jones and Leslie Sloan is that when you work in a world where everyone will just twist narratives and try to win the public opinion, there's no bounds, in my opinion, in terms of what they will perceive and try to twist in their favor. And it makes me really sad that this law that's in place to seemingly help people is being weaponized by a woman and a man, Blake Lively and Ryan Reynolds, because this case just isn't about Blake Lively. Ryan's as involved in this as her. And the media just, looking at Baldoni like he's a bad guy. There was a story today in the news about, there's a new law that the state of New York is considering, and it's similar to the 47.1, and it would have actions related to defamation cases like 47.1. And it was saying Jay-Z and Smokey Robinson and Justin Baldoni are suing their accusers. There are people that sue their accusers. This is true. There are abusers that use lawsuits as retaliation. That does not mean that every person that sues is retaliating. It does not mean that every person that accuses is telling the truth. And there's high stakes in the world of celebrity that most of us will never understand. And there's a lot of incentives for people to falsely accuse celebrities for a variety of reasons. We know that not all accusations are false, though, right? We know that what Diddy's going through is truth, right? There's real victims, and those victims are being believed. And we just hope that he's not pardoned by anyone and he goes to prison and he's found guilty, right? So when victims do come forward and we do believe them, there can be outcomes like criminal trials, what are happening to Diddy. Or when victims come forward and we do believe them and the court goes and they convict Danny Masterson, another example. But then, and Danny also said that his accusers were lying, just because abusers abuse the system doesn't mean that everyone that's being accused is truthfully being accused. And that's the problem with these kinds of crimes, because there's always doubt. It's why they're so hard to prosecute, because at the end of the day, unless it's a stranger danger assault where a woman is kidnapped or abducted and violently attacked, if it's someone that the woman knows, there is always going to be two sides of a story. And the man will almost always say that it was consensual to get out of it. And that's why cases like this are so hard. And prosecutors don't like to bring cases that they can't prove unequivocally. They can believe a victim, but still not bring a case. So Blake is the one that's bringing in this 47.1. She's the one that's getting these nonprofits riled up. Baldoni is trying to defend against it, but in his own motion to dismiss, he literally says that we don't have a problem with the 47.1. We have a problem with these treble damages and these draconian penalties. You can still have a claim where someone has a mechanism to try to get rid of a case without penalties. And there's another aspect that is working against Blake when it comes to these kinds of penalties and these types of cases. So, anti-SLAPP laws, and this is where it's bad news for Blake. Anti-SLAPP laws are anti-strategic lawsuits against public participation. SLAPP lawsuits are typically defamatory claims aimed at silencing criticism or public participation. They are often expensive and time-consuming, designed to discourage individuals from speaking out on public matters of interest. A lot of people use anti-SLAPP for when people come after the press, or if someone brings forth a matter of public interest and then they're sued for defamation. SLAPP laws or anti-SLAPP laws are controversial, though. And the Second Circuit, which is where the New York Southern District is located, doesn't allow or has a history of not permitting anti-SLAPP laws from states to be used within their courts. So states are the ones that have the anti-SLAPP laws. The federal government does not have an anti-SLAPP. The Second Circuit, which is where the federal district court is that they're located in New York, they ruled in 2020 and have consistently ruled against anti-SLAPP laws being allowed. There was a July 20th, 2020 ruling in the Second Circuit, and it struck down The U.S. Court of Appeals for the Second Circuit held that motions to dismiss based on state anti-SLAPP statutes, which requires that plaintiffs satisfy a high standard of proof in certain types of defamation cases, cannot be made in federal court because such motions rules conflict with Rules 12 and 56 of the Federal Rules of Civil Procedure. What the Second Circuit has said is that anti-SLAPP statutes do not apply in federal court. And I guess if you don't pay attention to the motion to dismiss, or maybe you briefed over it, this was actually addressed by Wayfair when they talked about her need for anti-SLAPP. And again, when I saw that they were trying to use anti-SLAPP in a New York court, in a federal court, I knew that it wasn't going to work. But they said that 47.1 cannot be used as a basis for an award of damages or fees for the same reasons that New York's anti-SLAPP cannot provide a basis for an award of fees consolidated defendants on their motions to dismiss. Application of the law at this stage of the proceeding would conflict with Rule 11 of the Federal Rules of Civil Procedure by imposing draconian and mandatory sanctions where a defamation plaintiff brings a non-frivolous claim that nonetheless does not survive a Rule 12 motion to dismiss. Rule 11 permits a court to impose sanctions only after the adverse party has been given notice and a reasonable opportunity to respond to and withdraw or correct the challenged paper. California Civil Code has no such requirement, and the party may seek sanctions without providing any advance notice to the adverse party. Under Rule 11, sanctions are permissive, while under 47.1, sanctions are mandatory. And they also argue that 47.1 would violate the United States Constitution because imposing treble damages on unsuccessful defamation plaintiffs would impermissibly burden the exercise of rights protected by the Petition Clause of the First Amendment. The only issue that is at issue in this case has to do with the damages that the 47.1 awards. That's the only thing they're arguing. And they're arguing that the same way that you can't use anti-SLAPP here because it's a violation of the rules, you can't apply this for the same reason. And because the Second Circuit has notoriously held that they don't allow anti-SLAPP in their courts, it's in the federal courts. Blake Lively could have avoided all of these issues. All she would have had to do is bring her claims in the state of California in a state court, where truthfully this should have been brought the entire time. And she didn't bring it to a California state court. Why? Because under California law, in order for her to have obtained the evidence that she has for her complaint, she would have needed to follow the California Civil Rules of Procedure when it comes to subpoenas, which requires that all parties are notified. It also has a third-party requirement that if an employer is going to be disclosing somebody else's, like an employee's information, that person has to be notified. So if it's like stricter than the state of New York in terms of notice. So even if the person, Stephanie Jones, has the phone, under California law, if she would have been subpoenaed under California law, she would have had to notify Jen Abel, and she would have had to notify Justin Baldoni. Blake Lively couldn't bring her case in California because she didn't follow the law of California to get the evidence. Instead, she used a sham lawsuit in New York. She forum shopped. But then she filed a lawsuit in New York and is now demanding California laws apply to her, where she wouldn't follow the California laws for the subpoena. She wouldn't follow it for the evidence. Had she followed the law in California, she never would have been able to bring this lawsuit to begin with. And that is at the root of this entire problem. Everyone is arguing about whether or not 47.1 matters or if it's going to be a shield for her. And many are ignoring that she violated the California rules when it comes to subpoenas. And the reason why she's filing this in New York is because of that. This case would be thrown out of a California court so fast because of what she did with that subpoena. She would have no evidence to bring into a court. And we're not even at the stage yet where Wayfair is going to ask that all of her evidence be thrown out, because that'll come. Truthfully, my guess, based on the way that the Second Circuit has handled anti-SLAPP, I think they're going to apply the 47.1 the same way. I don't know that they're going to make a decision on the constitutionality of it. I think they're just going to say, it's fine if you have these, but they're barred in this court. very similar to what they did with anti-SLAPP. I just don't see them allowing it because federal courts are very against sanctions of treble damages unless under very certain circumstances, and they very rarely award attorney's fees to anyone because of the constitutional rules, constitution, and all of these different rulings by the appellate courts and the Supreme Court that have reinforced that it's everybody's right to bring forth complaints and ask the government for help to redress their person that they want relief from. It's really hard to get sanctions in federal court. It's hard to get attorney's fees in federal court. And I just don't see a federal judge in the state of New York making a decision on a law that has nothing to do with the state of California, nothing to do with the state of New York. I don't see it being a factor in the motion to dismiss. And I think these companies that are coming forward, or these nonprofits, need to really ask themselves, why didn't Blake bring this to the state of California in the first place? Why did Blake use a sham lawsuit in New York? Why are all of you ignoring that? Tell me what your thoughts are in the comments below, but this is not good news for Blake. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed, and click the bell so you never miss a video. Thanks so much for watching. Bye, guys.